Just to introduce myself, my name is Raja, and I'm the founder of ClauseHound. ClauseHound is a database of contracts that are reorganized and re-indexed at the clause level, which allows the readers of contracts to really understand the finer points by comparing clauses, and also by reading and clipping notes at a clause-by-clause level. So where other informational sites provide a wealth of information, this can sometimes be difficult to access when thinking deeply about a specific clause. I personally encountered this problem when working as a lawyer for one of Canada's top law firms, and also when working for a British law firm. I decided to take action and to re-index contracts, and the result is a very deep and grainy database that is hooked directly into contract language, and that is now being used by thousands and thousands of people worldwide. I will now guide you through the framework of the NDA. The framework is comprised of 17 core elements. The first of which I want to discuss is recitals. The recital section of the agreement is where parties may want to outline the purpose of the non-disclosure agreement and the benefits or consideration that are being given and received by both parties. It should outline the story that leads to the creation of the non-disclosure agreement. Non-disclosure agreements are typically contemplated where one party intends to divulge confidential information to another party as part of a larger contractual relationship, and the disclosing party wishes to ensure that the recipient party does not use that information in a way that would be detrimental or harmful to the disclosing party. Examples include information that is shared in the course of a commercial negotiation or in the due diligence process of a financing, merger, or acquisition, or information that is shared with an employee, consultant, or service provider in order to allow them to complete their tasks, and so on. Recitals may include references to negotiations under which the confidential information is being divulged, or the underlying employment agreement, or any other circumstances which give rise to the sharing and protection of the confidential information that is the subject of the non-disclosure agreement. You can see in our knowledge panel we've provided this information for you for future reference. And some other information is provided regarding recitals specifically, and non-disclosure agreement recitals generally. And we've also provided you with variation language for recitals that can be injected directly into the contract. I now bring you to the definition of confidential information. This definition is important as it lays out the scope of the information that is to be protected by the non-disclosure agreement. And this definition will be different from agreement to agreement. In the context of M&A transactions, it could be relating to financial information and all of the disclosures that are provided in the due diligence process. For an employee, this would include matters such as proprietary information that is solely owned by the company, for example, work product information, financial information, business plans, intellectual property, technical information relating to computer systems and software, and so on. Also, in the context of an employment or consulting relationship, some companies may specify that anything that the employee or consultant comes across during their work period would be considered confidential information. So, a lot of the information that I've just provided to you in this webinar is available for you within the knowledge panel. And as well, we've supplied you with definitions from prior transactions. Some are simple and some are complicated. You'll have to read very carefully to consider which options are relevant for your situation. Now, on the topic of disclosure that is required by law, such disclosure may have several flavors, and one such flavor is disclosure required to comply with a regulatory framework And such disclosures could be contrary to a company's desire to keep certain information confidential to protect the secret sauce of products developed by that company. So this actually came up in an article that I recently reviewed and blogged about, and you'll find that blog post in our Clause Hand blog post. It relates to NDA and a provision in the Toxic Chemical Substances Act. Now, this recent article talks about the overhaul of this act and proposes that language within the act should be retained to prevent companies from having to disclose this confidential information, the properties of the chemical substances within their products in anything other than a generic way. And their argument is that by keeping things generic, it leaves incentive for the companies to innovate. By taking away the genericism and making it open, the companies will no longer have that incentive to innovate their products. The takeaway here, beyond the policy points on the merits of innovation and their arguments back and forth as to whether there's more innovation that could be sparked by having that information publicly disclosed. But the takeaway here is that when considering what is required by law in the context of your own client disclosures, consider whether there is room to disclose information in a non-specific way that will protect the trade secrets or the secret sauce of your company's product. It's useful to consider what it actually means to protect the standard of care. Practically speaking, when the language reads something like reasonable standard of care or similar standard of care as to what the manner in which the recipient would treat their own information, what does that practically mean? I'm just going to flip us to a blog post I've written on this topic on protection of confidential information. And within this blog post, I consider what this actual language should result in terms of the mechanical aspects of protecting confidential information. The recommendations I've come up with, and I've done this in a couple of different posts, include separating confidential information from the open areas within the office, ensuring that confidential information is key controlled, locked and guarded access, including a system for the monitoring and tracking of access to confidential information, ensure pre-screening and training of employees, ensure that confidentiality protocols are set in the company code of conduct. And I've further considered this in a post on data security, which I'll bring you to as well. And then in that post, I contemplate a periodic audit, an architecture relating to data security for user information and credit card data to ensure that those aren't held together, data security mandated access restrictions to prevent even restricted users from accessing all sections of data, additional audit requirements relating to security IDs and recycling IDs to make sure that people are not using the same ID and password over time, periodic stress tests and daily alerts and so on. So please take a read of this when you have a moment. I'd like to talk about the definition of purpose. So the purpose of a non-disclosure agreement is analogous to the consideration within a regular agreement. The purpose of an NDA is to formalize the rights and obligations in the relationship between the signing parties as it relates to the sharing of information. So an NDA agreement is not enforceable without some defined consideration returning for entering into the agreement. Purpose itself could be defined as for the purpose of entering into an employment agreement or for the purpose of entering into a future business relationship. This definition of purpose is important for a couple of reasons. One, it sets the consideration. And two, it sets the limitations. So quite often an agreement of this nature will state that the confidential information can only be used for that purpose. As you can see, the use of information is limited only to that purpose is a very frequent clause that we've captured through our knowledge database through past transactions. As well, definition of purpose is set out clearly in the beginning of the agreement. I'd like to talk a little bit about the handling of confidential information. An NDA normally includes language that deals with the safeguarding of confidential information, a standard of care. Companies may have both contract language and policies regarding the handling of confidential information. In the employment or consulting context, this is an important item to have in place so that confidential information isn't lost or disclosed due to carelessness. For example, by an employee or consultant who takes their work laptop home and allows another person to use it, or in another situation where an employee or consultant uses a public internet portal at a coffee shop, for example. Contract language to this effect often incorporates a minimum standard of care. And we've included variations on this language in our knowledge panel. Some of these variations include the handling of confidential information so that there is no less than a reasonable degree of care or handling in the strictest of confidence or at the highest standard of care. Lawyers and drafting counterparties should consider which situation and what standard is both appropriate and attainable and what is practical in the situations that they're dealing with. Disclosure where required by law has additional nuances to it, specifically requiring that, in many cases, that the discloser in this scenario will take additional measures to make sure that they're only disclosing information on a need-to-know basis, and as well are seeking appropriate counsel and offering appropriate notice to the owner of that confidential information, of the information being disclosed. And interesting things might happen if the conduct of the discloser isn't aligned with the rules for disclosure. So I've analyzed an article on this point just to provide a little bit more context within the Clauseham blog, and the article really tries to highlight the point that conduct of the owner of that confidential information may be taken into account when considering whether that information is truly confidential or whether it's possibly already in the public domain. So in one case, in Australia, the parties argued that information was no longer held confidential because the owner of that confidential information shared that information with their insurer in the context of litigation relating to a breach of the representations of the vendor in the case of the sale of a business. So in this case, the purchaser had obtained insurance for a possible breach of the representations and triggered that insurance, and therefore was in the situation where they possibly needed to disclose information that was to be held confidential. They did so. They disclosed that information in an unredacted way. The result was the court said, well, that information is now unredacted. The insurer is not your friend. The insurer actually may have an opposite interest from you because not only would they have to pay out insurance and in that case be aligned with you, but they also may want to take the opposite position that they don't have to pay insurance. And to support that position, they may further disclose that confidential information to their advisors and their counsel and so on. So the result was that information that was unredacted was found to be not privileged. And in this context of this argument was the counsel for the vendor was seeking to have the litigation privilege put aside so that they could actually access this unredacted information as well. So this whole scenario while not specifically in the context of a confidentiality agreement, highlights the point that the conduct of the owner of the confidential information should be aligned with the principles of confidentiality set out in that agreement. Otherwise, the confidentiality might be considered upset, and therefore the information might be already considered to be in the public domain. Confidentiality of the agreement itself may be a requirement in contexts other than what we usually see in business law, which is a mergers and acquisitions transaction generally, or a confidential agreement between commercial counterparties. It may also be the case in contexts such as in law enforcement. We found that to be the case in an article we recently read. Just popping over to our Clausehand blog, we'd uncovered an article regarding law enforcement agencies. And specifically within this article, law enforcement agencies were required to sign an agreement with the FBI to hold confidential many aspects relating to surveillance technology. And presumably within this contract, the reason for that, and as you can see here, most of this non-disclosure agreement was held to be confidential, was redacted and was enforceable in its redacted form by law. And presumably the reason for this is to prevent the public from accessing specific details relating to this surveillance technology for the purpose of reverse engineering and hacking and preventing the effectiveness of this technology. So the result of this is that it's important to note that the existence of a NDA agreement or the confidentiality of an NDA agreement can be held enforceable not just in the context of business transactions, but also in the context of law enforcement. The general duty not to disclose confidential information should be explicitly stated within the agreement. Normally it'll be found in the obligation section of the agreement. It may also be buried in certain other places. For example, in the obligations relating to confidentiality, language may read, "The confidential information shall be kept in strict confidence and shall not be used for any purpose whatsoever other than that purpose that was specified in the purpose for disclosure." This is akin to a general duty not to disclose. And we've provided several examples of this obligation, both in this section as well as in a subcategory called use of information is limited to purpose. You can see in this first example, the counterparty agrees that it will use all the transmitted information only for the purpose of providing, and again, it's that purpose. The counterparty will ensure that its employees will only use the confidential information for the purpose of this agreement. So this is a very tight restriction. It's usually a blanket restriction that the recipient of the confidential information will use their best efforts to preserve and protect the confidential information in the same manner that you would preserve your own personal information. There is some overlap with this clause and our discussion on the purpose, as well as our discussion on the handling of confidential information and safeguarding requirements. The most important point to take away is that a general duty not to disclose confidential information should be included within the agreement. We're discussing non-disclosure agreements. As suggested, please feel free to contact us through the chat interface with any questions you may have. The more questions we receive, the more information we can supply through our knowledge panel, which creates a nice and rich experience for anyone who's trying to understand these granular contractual points. So to discuss the next concept, let's talk about dissemination authorizations. So confidential information is intended to be kept confidential, except in certain circumstances. A safe harbor of confidentiality is allowed for folks such as advisors, employees, lawyers, those individuals that are specified within the confidentiality agreement as authorized representatives. to see that in the contract, let's scroll down to this clause here, dissemination authorized to representatives. As you can see, we're specifically stating who those authorized representatives are. And this carve-out is not a exclusion to the obligation of confidentiality, but rather it's an allowance to allow certain individuals to extend that confidentiality obligation to those individuals and to allow them to access the confidential information. Often this dissemination will be restricted to an as-needed or as-necessary basis. Authorized representatives will be liable for breaches of the general duty not to disclose as if they were signatories to the agreement through whatever contractual manner is specified within the agreement. The agreement will normally specify remedies, and there may be other contractual or tort claims that can be made with respect to an authorized representative who discloses the confidential information. We've included variation language on this point as well. So you may decide to find language that's more particular to your specific needs and include that or inject it into your agreement. We're continuing to discuss the NDA or confidentiality agreement. The confidentiality agreement sets out items that are considered to be confidential that are disseminated between counterparties. The agreement itself could also be considered confidential, if specifically stated as such. In this sample contract, you can see that the confidentiality of the agreement itself is included. This provision ensures that the negotiations and discussions that occur during the creation of this agreement and in contemplation of this agreement will also be deemed confidential, if that has been contemplated by the parties. This clause can be a separate provision or may be included in the definition of confidential information itself. Practically, what does that mean? It means that, for example, if companies are considering a merger or acquisition of each other, so considering whether to merge with each other, or if one company is considering the acquisition of the other, or a corporate finance transaction is being contemplated, or someone's considering the hiring of an employee, they may not want that discussion to be readily available. They may want to keep that discussion confidential in itself, so that the other party doesn't have the opportunity to go out and look for a better deal. In that situation, the existence of the NDA agreement itself would be considered confidential. Not having a confidentiality agreement really can highlight the issues related to a general duty not to disclose. So for almost every confidentiality agreement, this is the cornerstone, the most important element of that obligation of confidentiality is that you're, as a recipient, agreeing that you are not permitted to disclose confidential information. In absence of an agreement of this nature, parties would have to rely on common law to consider whether or not there is some sort of trade secret that is impliedly protectable, that some behavior between the parties, some conduct between the parties is creating some sort of implicit requirement for confidentiality. And that's difficult to prove. We took a look at a case in an article relating to this point, which we found very interesting, and that's found within our Clausham blog. Duties of confidentiality for independent contractors. And in this case, an article, we were interested to see that the court upheld the position that there is no duty of confidentiality that exists in absence of A, an agreement to that effect, or B, in absence of conduct that indicates the requirement for confidentiality. So in this case, an independent contractor had entered into an agreement to do some activity for this company, but there were no confidentiality clauses within this agreement. Furthermore, there was nothing to indicate, just through conduct, that the information provided, customer information, for example, was to be kept secret. So at the point in time when this independent contractor decided to leave the company, the company sued to say, return to us all the confidential information, and you're not permitted to disclose that information. This was dismissed by the court under summary judgment subsequently, and the reason for that is because there was no evidence, either contractually or otherwise, that would indicate that there was any veil of confidentiality around this information. So the court looked at factors including the existence of an agreement, which did not exist, the nature of security precautions taken, which the court found were minimal, if any, and the circumstances under which information was disclosed, and the degree to which the information had been placed in the public domain. And the court concluded that in this case, there were no expectations of confidentiality, and therefore, this case was dismissed. So the result here is that an employer or a company that's hiring an independent contractor should take care to make sure that they've indicated what information should be kept confidential, and likely should do so not relying on common law, but under the context of a formal agreement. We've been talking about non-disclosure agreements, and I wanted to bring up a new topic, which is exclusions on the limits of what is considered to be confidential information. Definition of confidential information includes specific items that should be treated with confidentiality. It's not uncommon for exclusions to be included within an agreement, and the purpose of this is to restrict those items that a recipient may already have in their possession, or may have in the future after the confidentiality agreement has terminated, or that might be available to the general public. So as you can see within our knowledge panel, a quick search on exclusions brings up several other scenarios that may be considered outside of the realm of what should be treated as confidential. We provided sample language for you to inject into the agreement at your convenience. And those things, as said, are exclusions related to items such as information in the public domain, information held by the party or developed independently, and information that is to be compelled to be disclosed if required by law. The last item, disclosures permitted where required by law, is often included in a confidentiality agreement. One thing to note is that even if it is required by law, it's useful to specify the scenarios and the limitations on that disclosure, and to give the company an opportunity to restrict that information from being treated as non-confidential. This is important as case law has shown that once information is treated as non-confidential in the context of court, third parties may have access to that information unless it's specifically restricted within the agreement, even in this context. The ownership of confidential information is contemplated within the intellectual property provisions of the NDA. Language is often included that sets out who owns the information that was transmitted. This will usually state that the right, title, and interest in the confidential information or the information transmitted will be retained as the exclusive property of the transmitter and must be held in confidence and possibly will be licensed to the recipient for the specific purpose of fulfilling their engagement with the company, the purpose of that NDA. In addition, it's often contemplated that if there is a jointly created intellectual property that results from the efforts conducted, that jointly created intellectual property may revert back to one of the parties. So a party may say that anything created through the efforts will revert back to us, and we continue to hold all ownership in our IP as well as anything created. These types of clauses should be read carefully so that parties who are coming in as equals are treated as equals. Or if a party is coming in as a owner hiring a service provider for a specific purpose, that owner is able to retain the intellectual property rights of the resulting IP. On the topic of representations and warranties within a NDA, these are usually very limited. There will be slim reps and warranties on certain items. Often a company or a discloser will indicate that information disclosed has no representation of accuracy. This limitation is intended to restrict any liability that might arise from transmitting confidential information to a recipient. This could be a negotiated point if the recipient is relying on the accuracy of that confidential information. Furthermore, there may be a representation on the part of the recipient that indicates that they're not in any conflict, that they are allowed to enter into this non-disclosure agreement free of conflicts, and therefore that the agreement shall be binding. A representation like this provides comfort to the discloser who might be worried that there's some other agreement at play that supersedes the obligations that are placed within this agreement. Clauses such as these are included in this agreement, in the sample agreement that we're looking at, including this clause here, which discusses the accuracy of confidential information. Additional clauses can also be found within the knowledge panel. Let's look now at the non-solicitation and non-competition clauses. Non-solicitation and non-competition are not core elements and are not included in all non-disclosure agreements. When companies are starting to explore the opportunity of working together, often a non-competition would be something that they would not want to include. It's too preliminary for the parties to enter into a negotiation around whether they're willing to consider themselves competitors or restrict themselves from competing on something that's a preliminary discussion. But to discuss those points further, when would you include a non-comp or a non-solicitation clause? These types of provisions are useful if the parties are sharing information that could be damaging to their business if it were used by the other party. For example, if they share client lists or sales leads, the recipient would and probably should be restricted from using these for their own advantage. And this would stop the recipient from engaging in any kind of relationship with a competitor of the business for a certain period of time and certain geographical restriction. As restrictive covenants by nature are restraints on trade, the scope of these restrictions must be reasonable under the circumstances. We've included some deep language on non-competition, including drafting points and guidelines, as well as variant language. I also wanted to discuss the non-circumvent very quickly. Often in a NDA, a non-circumvent may be included, which restricts the recipient to act on information given under a non-disclosure agreement outside of the scope of the agreement. For example, the company receiving sales leads is obligated not to circumvent the agreement to exploit those leads. That is, the recipient cannot use those leads for his or her own purpose without first providing this information that was gathered to the company. Usually, non-comp and non-solicitation and even non-circumvent provisions will survive the termination of the agreement. So for a certain period of time, the recipient of the NDA is still bound by these restrictions that are defined within these clauses. A provision is usually triggered at the end of an NDA or employment relationship, and that provision requires the return of confidential information upon termination. A provision such as this is very important, as was discovered by IBM in a case that we reviewed recently in one of our blog posts. Our post is entitled, "Why Every New Employee Should Be Asked to Sign an NDA." And this post talks about a case in New Zealand in which an IBM employee refused to return a laptop that was company property. So IBM's forensic team eventually unlocked this laptop and discovered that it contained personal information, videos, confidential recordings of company conversations, and so on. So thinking about the language within a non-disclosure agreement, the language should be strong enough to compel that confidential information be returned, company property be returned, and such information be returned in a way that includes passwords and allows the company to access those confidential materials. That type of language would make for a tight obligation in the event of termination. And on the employment law side, the employer would likely want to include language that either referring to company policy or directly within the employment agreement would require that company property only be used for company business and not for any personal business. Remedies in the event of a breach of a non-disclosure agreement can be set out in advance in an NDA. In the event that the recipient discloses information in contravention of the terms of the agreement or breaches some other material provision of the agreement, the company or the discloser would be entitled to several remedies, depending on what's contractually included. Those might include termination of the agreement, with or without penalties, injunctive relief, so a declaration or requirement that the recipient must stop certain actions or perform certain actions, and possibly damages resulting from the breach. And these remedies are not always mutually exclusive and may be granted simultaneously. Within this sample agreement, you'll see that we've included an injunctive relief clause. We've also included a clause that requires that the recipient is responsible for breaches by any of their representatives. The knowledge panel of our site also provides other remedies that could be used or drafted into the agreement, if appropriate, as well as case law and commentary on these points. The termination date is not uncommon in a non-disclosure agreement. Within this sample agreement, we've set out a termination date. There's value here because it'll set out the effective date of the agreement is set out in the term or effective date clause, and the termination date sets out the endpoint at which time information no longer should be disclosed, and depending on how the language of the contract is written, anything disclosed after that date should not be considered confidential information. So for a recipient, this is an important point, so that there's no open-ended situation of A, receiving confidential information, or B, a situation where the recipient is considered to be creating jointly created intellectual property, or C, possibly a non-competition provision might be in effect. So the term and termination clauses would be set out within the effective date and some sort of termination. And we've supplied you with sample term and termination, explanatory drafting points, as well as sample clauses. The effective termination is another important clause, and this clause sets out what happens to the confidential information once the agreement is terminated. Examples of obligations upon termination normally include such things as the return of all the confidential information within a certain amount of time, and or the destruction of confidential information, possibly the furnishing of a certificate of destruction that confirms in writing, signed by the recipient, that all the information that was received has been destroyed. And that certificate is useful if there's ever a situation where it appears that confidential information is still floating around or being used by the recipient. An injunctive relief clause is often included in a non-disclosure agreement. This is a particular remedy that requires, commands, directs that a company act in a certain way. For example, this order may be a requirement that the company stop disseminating confidential information, or stop using it, or stop a party from acting on it, or return that information. The party applying for an injunction usually has to show some sort of irreparable harm would flow from not granting the injunction. So we've included language to this effect. And in addition, within our knowledge panel, you'll be able to find additional language and drafting points relating to what's called injunctive relief or specific performance. In discussing non-disclosure agreements, our commentary contemplates that intellectual property may be generated out of that relationship that requires a non-disclosure agreement. We've discussed how that jointly created intellectual property may revert back to one of the parties. One of the parties may claim ownership over it. And to do so, an intellectual property assignment may be required. So you'll see in our sample language that intellectual property assignment is contemplated. This is outside of the normal ownership clause, and this clause relates to the handling of confidential information and provides that any of this jointly developed intellectual property is assigned back to one of the parties. This is not an uncommon situation where a party is hired for a specific purpose, where both parties realize that the resulting intellectual property shall be owned by the company or the discloser. The jurisdiction of governing law and of the forum for dispute resolution is hotly negotiated in all agreements, and non-disclosure agreement is no different. Our sample contract includes language relating to jurisdiction. In this clause here, the agreement is governed by the laws of insert, and all disputes, any disputes shall return to the jurisdiction of the courts of insert. And as you can see, we've included sample language as well as commentary on this point within our knowledge panel. Likely both parties will want the jurisdiction to be their home jurisdiction, and if they're in the same jurisdiction, that makes life easy for everyone. It's when the parties are in different provinces or states or countries where this can be a lot more hotly negotiated. And one resolution for this is to find a common jurisdiction, one that is central to both, and where the laws are similar enough to both of the original jurisdictions so that the contract can be negotiated and interpreted, and even a dispute can be resolved in a standard process and manner. For both parties, having to travel to negotiate can be a hassle and an expense, and to hire a lawyer to interpret the contract in the laws of another jurisdiction is an unnecessary and sometimes unavoidable expense. So in these situations, it's usually the party with a greater bargaining power that will win on the jurisdiction. But it's a point worth considering, and it's a point worth negotiating as well. To provide some context on the definition of confidential information, I looked to case law, and I have highlighted a case in a blog post on our blog site. So this post actually discusses the concept of common law versus contractual limitations on confidential information. So in a specific case that we reviewed in the context of an acquisition of mining property, a bidder on mining property had created a restriction in contract that said that information within this envelope of confidentiality could not be used to stake future claims by the parties who were receiving this information within a specific geographic zone. And that specific geographic zone was 1 kilometer away from the area of influence. So interestingly, the court found in favor of the recipient of the information to say that that information was only protected within the area of influence, within the 1 kilometer zone. Now, common law would have provided that information that's confidential is confidential, and it wouldn't matter whether it was within the 1 kilometer zone or outside of the 1 kilometer zone. So ultimately, there would have been more protection afforded under common law than under contractual law, but because in this situation the parties had agreed to voluntarily create this limit, the court confirmed that limit and provided that there was no confidentiality outside of that 1 kilometer zone. So the takeaway then would be, in the context regarding that provides a little bit of flavor regarding the definition of confidential information, is be careful that the language that you use within your definition of confidential information isn't actually so restrictive, so narrow in its breadth, that the result is that the recipient is actually able to use that confidential information in ways that were unexpected, that are outside of the desired limitations. Thank you for joining us on our tour of the NDA agreement, as well as of the ClauseHound Knowledge Database. We look forward to receiving your questions now using our messaging tool, as well as in the future at any time through the questions and answers and commenting features on our site. The more questions you provide, the more context we can provide on the finer points of drafting an NDA. To draw your attention to our terms of use, and remind you that ClauseHound, the information provided within these videos and within the ClauseHound website and database, is provided for informational purposes only. Copying, downloading, or use of any of the content on our website or through the video in any way does not create a lawyer-client relationship between ClauseHound and the listener, viewer, or reader. ClauseHound does not provide legal advice, nor should any information received from ClauseHound be construed as such. Please make sure to consult with a lawyer before drafting your legal agreements.